We now turn our attention to AI regulation in the European Union. Cecilia Alvarez Gordias from Meta will now speak on the topic of AI in the European Union and how to balance data protection with innovation. Cecilia, I'm happy that you're here today, and the floor is yours.
Thank you very much, and thank you for all of you who are following this wonderful Bitkom privacy conference.
Thank you.
So I hope that you can hear me well.
Yes.
Just checking. Super. Excellent. So thank you very much again. Well, the topic of AI is probably now in every single privacy conference, and this is definitely not an exception. I've been in the field for many years, close to 30 now. And I should say that I have been working with AI my whole life. It was not necessarily the sole subject at all, but it has been present in my professional life in the very different sectors in which I have been able to advise regarding the directive at the time of data protection and then the GDPR. But it seems sometimes lately that AI seems to be like a kind of completely new topic, or that we are always facing challenges that are completely novel. And I have first two reflections. One, that AI is definitely not new, but there has been, as always in the technology, rapid evolutions with respect to certain aspects of AI, in particular with respect to generative AI, that entails that this technology needs to be also studied in order to better understand the implications that we have in the different disciplines. And with respect to the challenges, definitely there are new challenges, this is true, but there are also challenges that are not necessarily new, but the context is the one that has changed. And of course, every time that the context changes, we need first to adapt this and to first understand what this technology is about. And this happened with the blockchain, it is happening now with GenAI, and it will continue to happen tomorrow with the next step that we will have in this technological evolution. And the personal data role is also something that we need always to rethink, because something that I have learned in all of these years of experience is that the data protection is always extremely contextual. And this matters, and this enables also the flexibility that the GDPR enables in order to get adapted and continues to be a piece of law of reference. However, I would like to share some thought with respect to an exercise that, despite the tools that we have in the GDPR, as a privacy community, maybe we have not been very successful at, and that it will be relevant that we maybe improve, in particular with this AI context. And I am referring in particular to the necessary balance among the fundamental rights and freedoms. But this fundamental rights and freedoms balance, that is something that is a given or part of the acquis with respect to how we should need to construe any kind of fundamental right, including data protection, needs also to be put again in context. And the context I would like to refer to are in the European ambitions on AI, because we should place this discussion into what the European Union is looking at. We have a European Union digital strategy that is basically aiming at improving our competitiveness, improving also the way in which we create jobs, improving our economic growth, improving our societal progress. And the way in which we have been doing this in Europe is focusing on two main pillars: the technology, and with a quite particular focus on AI, as we all know, and on the data, because the two things are important and indispensable in order for the European digital strategy actually works. And with respect to this data, is not only personal data, it's something wider that encompasses personal data and non-personal data. But as we all know, the difference between personal data and non-personal data is far from being an easy exercise, and probably this exercise has not been facilitated because of interpretations of the GDPR that have not been balanced again. So any discussion that we have in whatever discipline regarding AI and that we have in the European Union needs, of course, to be aligned with our European Union ambitions that are actually translated into pieces of law that are not, in this case, the GDPR, which is technologically neutral, but in other pieces of law, including the EU AI Act, but others, when I think about the pillar of data, the Data Governance Act and the Data Act, that are looking at improving the way in which we are accessing data and sharing data and enabling, at the end of the day, that the digital single market is a reality, is also another very important piece of the puzzle. So the GDPR interpretation is not an exception. So we need, again, as it has always been the case, to adapt our interpretation in the GDPR in order that it is coherent with the rest of the legal order, the one that we have been adopting, in this case, through the co-legislative process in the European Union. And as I mentioned before, we have a wonderful tool, and the GDPR continues to be a wonderful tool, as long as we continue to be faithful of what the GDPR says. I mentioned before the technologically neutral principle that we have in the GDPR. This is one that is extremely important. GDPR is not here to regulate AI as such, as it was not regulating any other technology, because it should be able actually to go across the evolution of the technologies and to focus on the personal data processing that is relevant for the purposes of the GDPR, which doesn't mean that just because there is a name in a sentence or in a book, in a shelf, that the GDPR is going to apply with respect to the kind of guarantees that we have taken so much time in order to have identified. The other very important element that we have in the GDPR to do this as well is that among the aims that we have, and this was inherited from the directive, was to contribute to have a single market, in this case, a data single market, which again is perfectly aligned with our ambitions regarding the European digital strategy, as I mentioned before. The GDPR is also a risk-based approach, which is also extremely important in situations like this one, in which, as every time that we have a new technology or new use cases, we are going to have situations in which we will need to actually assess the risks and the benefits of the cost of opportunity that we have of not doing a certain data processing or of doing it. And the last thing, which is not less important, because it is not something particular to the GDPR, but particular to any fundamental right and freedom, is that we have a rule in our legal order that is our fundamental rights are not absolute. And they require to be balanced in order that we maintain as much as we can in the kind of conflicts that we have every day regarding fundamental rights, that we keep as much as we can the essence. So it's not necessarily that we have a win and situation on one side and the other one is losing. Is that we need to be able to reconcile, and not necessarily 100% all the rights at the same time. It very much depends on this context. And let me zoom a bit more with respect to the context in which this construction of GDPR, with all of these tools that we have, should be effective. I think there is no single conference of privacy or another nature in which the Draghi report has not been mentioned. And this is extremely important because of the role that this person has been playing in the construction, actually, of our single market, but also regarding his considerations regarding the European competitiveness, among others. And the call to integrate AI vertically into any European industry, which is actually a very critical factor in order to unlocking, and I cite his own words, higher productivity, job creation, and reminding us that this is an issue applicable to both very large European companies and also SMEs, which is extremely important in all of our European countries. And I know that this is also the case for Germany in particular. So limitations within the EU to use the data in order to develop and fine-tune AI models that are not balanced will hold European companies back and will put European companies at a disadvantage relative to, for instance, companies that are operating in the US and China. And this is not something that I am just having my personal opinion. Again, I am citing the Draghi report. So with this diagnostic that we have and the wonderful tools that we have in the GDPR to do this exercise, why this is actually not necessarily working as well as it should be. We have seen as practitioners in the field that there is a fragmented interpretation and application of the GDPR by the relevant regulators within Europe. This, of course, does not contribute, just the contrary, of the achievement of these European goals on AI. It is a reality that we are seeing that our data protection authorities in the European Union are struggling to formulate individual positions or collective positions on how to construe the GDPR in connection to different aspects of AI, and in particular with respect to AI, generative AI model training. And therefore, the industry is faced with a lack of legal certainty. And this is not only with respect to those producing the models, but also who are using the models. The models at the end of the day they are not databases. They are just engines that enables to power products and services and powers, therefore, innovation that are going to be created, hopefully, by also European SMBs and who are actually our main champions in our European Union or other bigger companies as well. So when we think about how we develop this industry, we need to think about how we produce, which means the existence of the models per se, the training, the improvement, but also the use through open source. That is the case of Meta, who open sources its models and enables, therefore, that it is accessible to a larger part of our economy as well, but with respect to other models, we can say the same, even if probably the accessibility to the model is linked to other kind of barriers in terms of cost or otherwise. So what do we need with respect to this construction of the GDPR? We need a construction that is coherent with the European digital ambitions with respect to the fact that we want to have AI developed, that we want to have data use enhanced, and we want to have a digital data market. And this requires harmonization, but harmonization in a certain manner, which is my second point, which is balanced. That is coherent first, but balanced in accordance with respect to the rules that we have in the Charter and with respect to having much more focus on the safeguards that we can put in place. And it should also be, in addition to be coherent and to be balanced, it needs to be informed. We cannot operate or try to construe a processing activity that is going to be related to a technology if we do not understand this technology. So the technical expertise is actually something that is very relevant in order actually that we may apply our legal concepts and our values and traditions in order to get this balance the best way that we have. So to be productive in this exercise, we need to continue being faithful to the GDPR. And being faithful to the GDPR is not to be restrictive for the sake of being restrictive. It's to be balanced, which is actually something that is reminded even in the text of the GDPR. If we just go to recital 4, it's just a reminder of a rule that it seems to be a bit forgotten. And I would like maybe to make a specific point with respect to part of this interpretation traditionally that has not been helping, I think, us in general with respect to this idea that I think is a misconception that the only thing that protects is consent. There is no hierarchy, as we know, in the GDPR among the legal bases, and each of the legal bases, and sometimes there are many actually that may apply to a certain or a given situation. But the fact that we think about consent all the time, I think is not necessarily the avenue. It's not that it is part of it, but it's not necessarily always the better. And it's actually not always the most protective way of doing this, despite what maybe we can think. I understand that consent is easier to understand, is a kind of binary thing, yes or no, rather than the legitimate interest, which has been a legal basis that, depending on the countries in the European Union, have been very scarcely used, despite the fact that we have a certain number of references in the GDPR, not only to the existence of the legitimate interest, but also cases in which it is understood that the legitimate interest exists. But also we have DPA resolutions, some of them, and we have Court of Justice decisions that are also relevant in this respect. And let me just remind us as a privacy community the importance of Court of Justice decision that we had some time ago in something that is pretty similar to the kind of situation that we are having now, which is the Costeja case, the case of the right to be forgotten. At the time in which the Court of Justice was actually doing this balance among fundamental rights that I was talking about between the freedom of information and the right of privacy. And regarding a scenario in which we were having search engines that are actually facilitating this freedom of information by having access to publicly available data that, of course, may encompass materials and contents that have names in it or that have faces, if we speak about images per se. And the way in which the Court of Justice resolved the conflict between privacy and the freedom of information was actually to focus on the safeguards and to focus in particular also on how to construe the right of objection in this case in a pragmatic manner, in the sense of something that is adapted to the context that they were analyzing. And what did they do there? It was an objection that was coming exposed with respect to a request, an active request from the data subject that was able to identify the piece of information that was related to him or to her and that was, in their view, damaging them, and with a certain number of criteria actually for the search engines to assess the merits of this request in order to do the balance that is required on the legitimate interest balance test, which is pretty similar in terms of exercise of what I am talking about. And then to determine as to whether in this case the data were not necessarily removed from the source, but they were dereferenced. So the way in which the Court of Justice actually was operating is first with a balance of rights, and then also using some kind of innovation in the sense, let's adapt this actually to the new situation. We didn't have search engines before, and now it seems almost that we cannot live. And actually, I read an article of a professor, a Dutch professor quite recently, who was saying that the LLMs and the generative AI models that we have right now are kind of search engines with steroids. I found the image quite illustrative and remind me very much about this Court of Justice decision, but also the methodology that is behind, which I think is very important. And this is something that, again, is very relevant for us as Europeans to be able to think that the ambitions that we have, we are able actually to do this. Let me finish because we are at the top, I understand, of the time that is allocated for my intervention. My last comment will be that in order to do this exercise, we should do it together. It is not very useful to have regulators and regulatees working not together. So public consultation and to have another mindset in which we really need to work together on this is, let's say, my call. So that I would like that maybe we think also as a privacy community of how we are going, let's say, to be able to intervene in a collaborative manner regarding the exercise that the data protection authorities are doing now closed doors regarding their opinion on AI that is going to end on the 23rd of December. So as a Christmas present, I would like to have more collaboration in the field. Thank you very much.
Thank you very much, Cecilia. So far, we don't have any questions. So yeah, thank you once again for your keynote and have a good day.
You too, and auf Wiedersehen.
Auf Wiedersehen.
Dankeschön. Bye.